All rise. The Lawyer of the Apes is now in session. What's up, everyone? How's it going? Episode 12. I had every intent on doing a video today on burdens of proof, but for a different reason. I was doing the burdens of proof video because on Monday, October 25th, we have that SEC versus Citadel case coming up, and I wanted to go over the different types of burdens of proof because I keep seeing like Fox and Reuters and other various media sources on Google when I do searches for this SEC case, calling it a lawsuit. That Citadel filed a lawsuit. It's not a lawsuit. As I said before on my posts, this was an administrative order that was approved by the SEC. SEC approved the limit, right? And then this is an appeal of the administrative order. So it goes right to the Court of Appeals, U.S. District of Columbia. So basically, I'm going to go over the burdens of proof for that. And then, like I said, we're going to be doing a live stream of that on 10/25. I'll have more information for that soon. But just want to coincidentally, today, just in time for Halloween, Chucky went on a rampage, and I'm not talking about Chucky from Child's Play. I'm talking about Charles Gasparino. He went off on Twitter today. I saw Trey had made a post on his page. I had made a comment on it, and he responded to the comment, saying something really outlandish, and I'm going to pull it up for you guys right now. He said, the SEC just proved beyond a doubt there is no widespread naked shorting abuse, no MOAS, no dark pool abuse, all these stuff. That's, you would put SIC, SIC there when there's some type of a bizarre spelling error. All this stuff you guys have been touting is now off the table. Now, again, this isn't the court of law. This is a court of public opinion. In a social media space like this. But when you make statements, especially when you're somebody who's in the media, and you claim to have a level of credibility, when you say that the SEC Gov report proves beyond a reasonable doubt that there is no widespread naked shorting, that shows two things. One, that you really didn't read the report very carefully. And number two, you have no idea what burdens of proof are, because beyond the reasonable doubt standard is such a significant standard. So this lesson today, or what I'm going over today to inform the apes, is now it's like a little lesson for Charles as well. I want him to have a better understanding of the different burdens of proof, because there is no way that even in the court of public opinion could that report be considered proof beyond a reasonable doubt of anything at all. The report on its face is a skeletal report, and I believe, and I said before, I believe it's intentionally skeletal because of ongoing litigation. It makes sense for the SEC not to give their opinion while litigation is pending, especially on something so important as the issues that are being brought up in the lawsuit that's currently filed in Florida. So let's talk about burdens of proof, all right? So there's civil cases and there's criminal cases, right? So let's talk about civil cases first. In civil cases, there's generally two standards of burden, right? One is called a preponderance standard and one is called clear and convincing standard. So depending on what type of cause of action you're bringing, that will determine the level of evidentiary proof you need to establish a civil case. So usually for something like a personal injury, a breach of contract, that is a preponderance standard. So what does that mean? That means the plaintiff has to prove their case basically by 51%. So think about a scale, right? Some weighing facts on each side. If the scale tips to 51% probability, then that means the plaintiff wins. If it tips off to the other side, then they should find for the defense. So it's basically, if you have two sets of facts and you're right in the middle at 50-50, if it kinks over to one, on the plaintiff side to 51%, then the plaintiff should win. If it kinks over to the left, to the defense side, 51%, then the verdict should go for the defense. So that's basically preponderance of the evidence. It's the lowest standard, right? That is the lowest standard. So again, I don't even think that based upon that SEC report, which cites 90% to media and media articles and media sources. I mean, it reminds me of when I was in college, and I remember submitting a paper, and I was a young kid, and the internet really had just started coming out. I'm 40, so at that time, you know, it just really, like, you really just started doing a lot of research on the internet. Not as much as obviously we do now. We had just started, and I remember I cited to a bunch of .coms, and I cited to a bunch of, you know, media pages. And I mean, he sent me back that paper marked up pretty severely, and basically said, you're citing to shit. And that's the reality. That is what was being cited in that paper. The media, you know, it changes constantly. And the media is, especially in this day and age, media, and depends on which media you're watching. Media is not, you know, what it used to be. It's not, you know, cold down the middle. It depends on which outlet you're hearing and what their motivations are and what they're going to talk about. Gasparino is a great example. He keeps referring to the SEC report, but he never mentions the fact that there's a pending litigation in Florida related directly to what happened in January, related directly to short interest issues, related directly to everything that we're talking about. So the second standard in a civil case is clear and convincing evidence, right? Clear and convincing evidence is a standard right above preponderance of the evidence. It's high, but not the highest standard of all in legal cases. It is the highest in civil cases. And usually a clear and convincing is for a fraud case. If you have to prove fraud, usually that is, you have to show a higher standard of proof of fraud. So clear and convincing, it's open to interpretation, I guess you can say. It basically requires the plaintiff to show a very high probability that the facts are true and in their favor. High probability. That is the standard, and it's kind of open. But you know, you probably say, well, if it's 51% on the preponderance standard, then maybe you're looking at like 75, 80%, right, on the clear and convincing standard. And then we get into the highest standard, right? The highest possible standard, which is beyond a reasonable doubt. Now, beyond a reasonable doubt is a standard that means definitive, like 100%. There's no doubt at all, right? No doubt at all. So if someone commits a crime and you have to prove it, there can be no mistake. There can be zero mistake. If there's even a fraction of a doubt in your mind, even if it's 0.009%, you cannot find in favor of a verdict against someone for committing a crime. So the fact that Gasparino is going around touting that the SEC proved beyond doubt, which implies reasonable doubt, right, that this report shows that there's no shorting abuse, no MOAS, no dark pool abuse, is completely disingenuous. It's completely disingenuous. And it's kind of odd that somebody, well, it's not odd. I mean, we know, you know, why he does it. But the reality is there's no reason why someone who is a reporter should be going around editorializing in this way. If you want to editorialize, at least be accurate in your editorialization. And that there's one other standard that I want to go over, and it relates directly to the Monday hearing, oral argument that's going to be before the Court of Appeals. So when decisions are ruled upon by an administrative agency and also an arbitration sometimes, when those cases get appealed and they go before the appellate court, that's a different standard. That is not, you know, that's why I was saying that you can't call it a lawsuit, you can't call it litigation, because when you talk about lawsuits and litigation, you're talking about preponderance, clear and convincing, it's criminal beyond a reasonable doubt. That's for lawsuits. This is not a lawsuit, this is an appeal, right? And the standard is different. So in this case, on Monday, you're talking about what's called a standard that is outside of the realm of these, and it is basically known as arbitrary and capricious. That means that the decision that was made by the administrative agency was completely made without any factual or legal basis at all. They basically woke up one morning and said to themselves, you know what, I feel like implementing delimit order today. And then just did it without any prior background, without any legal research, without any rationale. They just woke up and was just on a whim and said, sounds good. That's basically the standard. They have to prove that it was that bad. They have to prove that it was that egregious of an implementation. So that's a really difficult standard. So anyway, guys, I just wanted to do a quick video on burdens of proof. And I have, like I said, it was originally just going to be based upon the whole thing with the hearing on Monday, but then we have Chucky here, trying to undercut the apes in the retail community. So I had to come out with this extra little bit in that regard. So anyway, guys, thanks for following. Hit the like button if you enjoyed. Please subscribe. Please keep spreading the word about the channel. I really appreciate it. And until next time, the Lawyer of the Apes is adjourned.